All right, good morning, everybody. It's great to see everybody here at 8:30 in the morning. It's another beautiful sunny day in Cleveland. For those of you from out of town, this is what is the result of global warming. All right, for those of you who don't know me, I'm Michael Scharf. I'm the co-dean of the law school, and it is my great pleasure to welcome you to today's Cox Center conference. The conference is organized by the Frederick K. Cox International Law Center, which is celebrating its 28th year since it was endowed with a $3 million endowment. And our international law program, based on the wonderful professors, several of who are here, I see Associate Dean Avi Cover in the audience, and others, are responsible for the fact that over the years, our international law program has really blossomed. And it has been ranked in the top 20 of the international law programs in the country, according to U.S. News and World Report, for the last 10 years. And it got an A+ this year in Pre-Law magazine. And it's really one of the jewels of our law school. This conference has also been designated by the International Law Association's American branch as International Law Weekend Midwest. And we're very, very pleased to have that designation. And those of you who are tuning in by webcast, we hope you enjoy it. It's also co-sponsored by the American Society of International Law, the American branch of the International Law Association, the International Association of Penal Law, the Cleveland Council on World Affairs, the International Law section of the Cleveland Metropolitan Bar Association, and the Greater Cleveland International Lawyers Group. And for those of you who represent those different groups, thank you very much for your support. I want to thank our speakers. We went with a very ambitious invitation of the top speakers, not only from the United States, but from all over the world. And we got so many yeses that we decided to transform the format of most of the conference into roundtables so that we could put more people there and everybody could participate. And I personally love the roundtable format. It's much more exciting and it keeps me awake. So we are going to start off with the president of the American branch of the International Law Association, and that is Layla Sadat. She's the James Carr Professor of International Criminal Law at Washington University School of Law. She's the director of the Whitney R. Harris World Law Institute. She holds a very impressive position at the International Criminal Court, and she's a star in the field of international criminal law, and we're always happy to have Layla back. Layla?
Thank you, Michael. And Michael is such a wonderful organizer, and it's always a pleasure to be back at Case Western University. And I think what I particularly appreciate about Dean Scharf and about Case is he brings international law to the Midwest in a really significant way. And in an era when international law maybe is under siege, it is really nice to see a locus and a focus and a true energy around this topic here in Cleveland. So I was asked to say just a couple of words about the International Law Association. It has 4,500 members in 63 branches worldwide. I am the president of the American branch, which is one of the oldest branches, not the oldest branch, because the ILA was actually founded in 1873 in London. And it was founded, I learned more recently, at the instigation of Americans who wanted the Europeans to focus more on international law. Doesn't that sound kind of strange when you think about it in current context? So the American branch is one of the larger branches, but we're by no means the only branch. We have sisters and brothers all over the world. We have a signature conference which is held every fall called International Law Weekend in New York. It's very, very inexpensive. It's only $25 for members of our organization, and it's free to students. So anybody who wants to go really can go. I see many chairs, committee chairs, panelists, co-panelists, a vice president of the organization, a member of the board of directors. I saw Jen, who's also one of our board members. It's a wonderful small organization that I had the honor to be part of for many years and now to lead. succeed. So we are very proud to sponsor International Law Weekend Midwest. CASE has done this at least twice now, I think. The idea is to bring international law into the heartland, into the west, into the south, into the north, and not just think of it as something that happens on the coast. With that, I wish you a wonderful and splendid conference. ILA is very proud to be part of this, and I look forward to our discussions today. Thank you.
Now it's my pleasure to introduce Professor Milena Stereo of Cleveland Marshall College of Law. She is the president of the American National Section of the International Association of Penal Law, one of our co-sponsors, and by tradition, we often are the venue for the presentation of the annual Book of the Year Award, and Milena is going to present that.
Thank you, Michael. It's great to be here, and I'm sorry that I had to miss last night's festivities, but in my day job, I teach law here at the Cleveland Marshall College of Law, and I have an evening class on Thursday evenings. So, but it's great to be here today. So I currently serve as president of the U.S. chapter of the Association Internationale de Droit Pénal, the International Association of Penal Law. And we're actually lucky that here in the room we have two past presidents of the U.S. chapter, Professor Mike Kelly and then Dean Michael Scharf. So first of all, and most importantly, if you're interested in joining, please let me know. We'd love to have new members. It's a wonderful group. We have our international plenary, if you will, coming up in Rome, and from time to time we do other meetings. So if you're interested in joining, please let me know. Now, as Dean Scharf has mentioned, here at this conference, we have in the past given out the award for the AIDP Book of the Year. And I'm pleased to announce that this year's winner is The Legacy of Ad Hoc Tribunals in International Criminal Law, assessing the ICTY's and the ICTR's most significant legal accomplishments. So we have a copy of the book here, and we have extra copies for everyone in the audience. This was edited by Dean Scharf and myself, and features chapters from some of the conference participants, including Professor Paul Williams, who will be joining us later today, and Professor Jennifer Trahan, who is here. So thank you, Jennifer, for contributing the chapter. So with that, I will. Congratulations, Michael. And with that, I look forward to this wonderful conference. Thank you.
Thank you. Oh, it's nothing like throwing a party and giving yourself a present, right? I'm so surprised. All right. So what's really wonderful is that we get to kick things off with one of the superstars from the United States in the field of international law, and that's Sean Murphy. Sean is the Manat Ahn Professor of International Law at George Washington University. He's the president of the American Society of International Law. He is a member of the UN International Law Commission, where he serves as Special Rapporteur for Crimes Against Humanity. He's an award-winning author and has served as legal counsel at the U.S. Embassy in The Hague, where he argued several cases before the International Court of Justice and represented the United States in matters before the International Criminal Tribunal for the former Yugoslavia. His resume is super long, but I've known him for 30 years and have seen him through all of this. And the best thing anybody can say about him is he's one of the most nice people and well-respected people in the entire field. So without further ado, Sean Murphy.
Well, thank you, Michael, for that very kind and warm introduction. It's really a great pleasure to be back here and to be a keynote speaker for this wonderful conference. My thanks to Dean Scharf, my thanks to the Frederick Cox Center, which really has done amazing things in the years since it's been established. It's well known not just throughout the United States, but around the world. So it's a real credit to what CASE has been able to do in this area. And my thanks to the co-sponsors of the conference as well. I do think we've assembled here, Michael's assembled here an extraordinary array of very talented speakers on a topic that is extremely timely, atrocity prevention. I think we all have pop into our minds places like Yemen or Venezuela or North Korea or Syria. It doesn't take much to just conjure up why a topic such as we're dealing with today is of great importance. I'm pleased, in part as president of the American Society of International Law, that this conference is going forward because last year the American Society launched a signature topics program where we selected 2 topics that we felt we wanted to focus as much as possible society activities on. And one of those 2 signature topics was the topic of atrocity prevention. Todd Buchwald, who I think is here today, is the chair of the steering committee for the Society on that atrocity prevention topic. Michael Scharf's a member of that committee. It's wonderful to see this conference in part being plugged into the initiative that the Society thought was so important. I'm also pleased, putting on my hat as a member of the International Law Commission, that it's an opportunity to talk a little bit about the ILC's draft articles on prevention and punishment of crimes against humanity. Important not just because it's a good topic generally, but we just finished our work on those articles. They were adopted in final form just 1 month ago, and they have now been sent to the UN General Assembly for action this fall. So it's an extremely timely time to be thinking about those articles as a whole, and also in the context of prevention, which is what I'm going to focus my remarks on this morning. I'm delighted we also have a panel later today, panel 4, I think it is, looking at the draft articles as a whole. I've titled the keynote address as Codifying the Obligations of States for the Prevention of Atrocities. Codifying the obligations of states for the prevention of atrocities, possibly with a subtitle From the 1948 Genocide Convention to the ILC's 2019 articles on crimes against humanity. Now, in addressing these obligations of states, I'm not going to be focusing on the functioning of international institutions. So I won't really be talking at all about the UN Security Council. That's the subject of our first panel today. And I'm not really going to be talking about the International Criminal Court, which is the focus of the 5th panel. Rather, my focus is going to be on international obligations embedded in major multilateral treaties that address the issue of prevention of atrocities, either express or implicitly in the treaties. And in that context, the relatively brief time I have, I'm going to focus in on what was it the International Law Commission thought were the key obligations that should be imposed on states if you're going to adopt a new convention, which will be focused on prevention, in part, of crimes against humanity. Before going into what I will identify as 6 obligations of states that were grabbed by the ILC and put into the draft articles, let me say a little bit about the historical background. And the reason why the historical background is important is that the International Law Commission was not operating on a blank slate in thinking about how do we prevent and punish crimes against humanity. It was looking at major multilateral treaties dating back to the 1948 Genocide Convention. It was our view that states were aware of these kinds of instruments, had often ratified these instruments, were comfortable with the types of provisions that were in them. So a lot of what we did was analyze prior multilateral treaties and thought about what they meant, thought about how they had been interpreted by international courts and tribunals, had been interpreted by human rights committees, and from all of that extracted what we thought were the core obligations relating to prevention that should be embedded in our articles on crimes against humanity. So if you go back to 1948 and you go to the Convention on the Prevention and Punishment of the Crime of Genocide, you'll find there 3 obligations focused on prevention. So Article 1 of the Genocide Convention says the parties confirm that genocide, whether committed in time of peace or in time of war, is a crime under international law which they undertake to prevent and to punish. So prevention's right there in Article 1. It's also in the title of the convention itself. Article 5, the parties undertake to enact in accordance with their respective constitutions the necessary legislation to give effect to the provisions of the present convention. So, if in Article 1 you have an obligation to prevent, in Article 5 you have an obligation to enact national laws that will implement that obligation to prevent. And then in Article 8, it says any contracting party may call upon the competent organs of the United Nations to take such action under the Charter as they may consider appropriate for the prevention of the crime of genocide or acts of genocide. So in the Genocide Convention, 70 years ago, you've got three relatively important types of obligations relating to prevention. Now, what happens from that period forward is pretty much every major multilateral treaty adopted relating to crimes contains prevention obligations of one kind or another, echoing those kinds of obligations from the Genocide Convention and carrying them somewhat forward. Now, I'm not going to talk about all of those treaties, but let me just list out a few of them so that you have a sense of it. 1971 Convention for the Suppression of Unlawful Acts Against the Safety of Civil Aviation. That's basically one of the early terrorist-related conventions, but think about that, suppression of the acts against safety of civil aviation. 1973 Convention on the Prevention and Punishment of Crimes Against Internationally Protected Persons. This was a treaty that actually also came out of the International Law Commission, and so the Commission paid particular attention to what did we do back then. 1973 Convention on the Crime of Apartheid, right? The title is Suppression and Punishment. Suppression and Punishment of the Crime of Apartheid. 79 Convention on Taking of Hostages. 84 Convention on Torture, which many of you are going to be familiar with. Coming up more to the present, in 2000, the adoption of two protocols to the Convention on Transnational Organized Crime, one focused on trafficking in persons and one focused on smuggling of migrants, both with provisions relating to prevention. And then perhaps most recently, the one that you'd be aware of is the 2006 International Convention on Enforced Disappearance. Now, there are also some human rights treaties that are not specifically addressing crimes, but nevertheless have prevention-related provisions that the Commission also thought were quite important. So if you look at the CERD Convention, right, the 1966 Convention on the Elimination of Racial Discrimination, you will find provisions that talk about suppression and prevention. Or if you look at the CEDAW Convention, Convention on Elimination of Discrimination Against Women, talks about how do we not engage in discriminatory acts ab initio rather than just address them after they occur. So these treaties also have some relevance to the way in which you'd be thinking about prevention of an atrocity. You've also got some human rights treaties. The ICCPR comes to mind, International Covenant on Civil and Political Rights, which doesn't use the word prevention, doesn't use the word suppression, but does require a state to give effect to the rights under the convention or to implement the convention. And to the extent that the whole point in the convention is to establish rights that the individual should have and should not be denied to it, this too leads into a conversation about prevention. So that's the historical backdrop. We looked at all of those kinds of treaties to try to distill down into what might be a 2019 Convention on Prevention of Crimes Against Humanity, and we came up basically with 6 legal obligations. I say basically because there's sub-obligations in here and whatnot, but for purposes of this talk, I'm reducing it down to essentially 6 core obligations upon states. So, obligation number 1, states themselves shall not commit crimes against humanity. States themselves shall not commit crimes against humanity. Now, you might say, yeah, of course, that's what this should be all about. What's interesting, though, is when you look at those prior multilateral treaties, let's go back to the Genocide Convention. In the Genocide Convention, there is no provision that expressly prohibits a state from committing an act of genocide. The provisions that I read out to you there, starting with Article 1, talks about a state preventing the crime of genocide, but it doesn't actually say the state itself should not commit an act of genocide. Now, this came up in the Bosnia v. Serbia genocide case. Bosnia is saying, you, Serbia, engaged in an act of genocide in the context of your support for the Bosnian Serbs, including the massacre that occurred at Srebrenica, right? Serbia says, well, wait a minute, look at the terms of the Genocide Convention, and nowhere there does it say a state party shall not commit an act of genocide. The court looks at this and says, yeah, that's not a very good argument. You've undertaken an obligation to prevent acts that constitute a crime against genocide, the crime of genocide. It must be the case that you yourself also have an obligation, not as a state, not to commit the acts. I'll just read a couple sentences from the judgment. The article, talking about Article 1, does not expressis verbis require states to refrain from themselves committing genocide. However, in the view of the court, taking into account the established purpose of the convention, the effect of Article 1 is to prohibit states from themselves committing genocide. And later on it says the state's parties must logically be undertaking not to commit the act so described. I think that was the right conclusion. I think you could read that conclusion into other major multilateral treaties that obligate states to prevent a particular crime. The Commission ultimately decided we wanted to make it express. We did not want to just leave this to an implicit understanding of the meaning of the convention. So, in Article 3 of the Commission's Articles on Crimes Against Humanity, in paragraph 1, it says, each state has the obligation not to engage in acts that constitute crimes against humanity. Express obligation. Now, there's an interesting backstory to that, because you might say that formulation is longer than it needs to be. Can it just be each state shall not commit crimes against humanity? The backstory is that when the Commission was working on the Articles on State Responsibility back in the 70s, 80s, and 90s, the idea of states committing crimes was a part of the conversation. And it was very controversial. And there were those that said, yes, states can commit crimes. No, persons commit crimes, not states. And so there's big back and forth. When James Crawford became the special rapporteur, the final special rapporteur for the Articles on State Responsibility, he knocked out that whole idea of states committing crimes. And that's partly how we were able to ultimately, in 2001, complete the Articles on State Responsibility. So the Commission's approach was to say each state has the obligation not to engage in acts that constitute crimes against humanity. So it's a way of indirectly connecting the state to actions that in the context of going after persons are crimes, but in the context of the state, it's just acts that constitute crimes against humanity. So we included that obligation. It is the case that the Commission views that obligation of not to engage in acts to include the state not aiding or assisting or directing or controlling another state to engage in such an act. And that too is an important component, and it raises some questions about what does it mean to aid and assist another state in the commission of the act, but that is a part of what this obligation is all about. We also make clear in the commentary that the violation of this obligation, like the other obligations I'm going to talk about, engages the state responsibility. That is, if you breach it, it's the basis for another state to bring a claim against you, or others, depending on the fora, to bring a claim against you for having violated international law. It does engage your state responsibility. Okay, obligation number two. Obligation number two. States shall prevent others from committing crimes against humanity. So it's not just the state itself, its organs, persons that it effectively controls. That's obligation number one. But states shall prevent others from committing crimes against humanity. So think back to the Bosnia-Serbia case. Serbia is sitting there not directly or effectively controlling the Bosnian Serbs, but they have influence with them. They have a capacity to influence them. And the court talked about this in the context of that situation and said that this obligation to prevent, embedded in the Genocide Convention, expressly embedded in the convention, includes an obligation to employ the means at your disposal to prevent persons or groups not directly under your authority from committing, in that instance, acts of genocide. Okay? Now, when you read what the court said, it characterizes this type of obligation as a best efforts or due diligence obligation. It's an acknowledgement that they're not directly under your control, so you don't have an on-off switch. But if you have a capacity to influence effectively the action of the persons who are likely to commit or have already committed the acts, then you should take steps. Now, it also talks about how this may depend on the context. In context, do you have a relationship with this entity, these persons, this group? Are they geographically proximate to you? Do they have some other political connection or link to you? This is not saying every state worldwide will have this capacity to influence. It depends on the context. Nevertheless, that general obligation does exist, and the Commission has included it basically in Article 3, Paragraph 2, where we talk about states undertaking to prevent crimes against humanity in the same way they have that obligation under the Genocide Convention. Okay, obligation number 3, states shall take legislative or other measures to prevent crimes against humanity. This third obligation was crafted in Article 4 of the Commission's Articles on Crimes Against Humanity in subparagraph A. And basically it says that states have to take effective legislative, administrative, judicial, or other appropriate preventive measures in any territory under its jurisdiction. Now, I just said in any territory under its jurisdiction. I didn't use those words for the first two obligations. The first two obligations are not limited territorially. If you're directly engaging in acts of crimes against humanity somewhere outside your territory, you're caught under obligation 1. If you have a capacity to influence others outside your territory, you're caught under obligation 2. Here, the obligation to take legislative or other measures is territorially limited. The idea being we're looking more at sort of the longer term adoption of national laws or regulations or actions by courts and so on. These are things that are going to happen in your own territory. We do talk about territory under your jurisdiction. So there's a little bit of wiggle room there. It may not be your de jure, just your de jure territory. If you're exercising jurisdiction over a territory, think occupying territory, perhaps, that de facto jurisdiction also is caught up in this. So in those places where you have that kind of control, the obligation operates. What does this obligation require exactly? Well, it's going to depend on the context. But when you look at the way it's been interpreted by other bodies, and I'll start with the Human Rights Council. The Human Rights Council in 2015 adopted a resolution on prevention of genocide. And in that context, it said that member states should build their capacity to prevent genocide through the development of individual expertise and the creation of appropriate offices within governments to strengthen the work on prevention. It talked about states appointing focal points on the prevention of genocide, and it talked about cooperating with the UN, including the Special Advisor to the Secretary General on the prevention of genocide. So these are the sort of standing measures that might be taken, some of the standing measures that might be taken. Since I just mentioned the Special Advisor to the Secretary General on the prevention of genocide, I'd note that my hope is if we end up with a convention on prevention and punishment of crimes against humanity, then institutional structures like that will be broadened out. We should have a Special Advisor to the Secretary General on the prevention of genocide, crimes against humanity. Maybe we throw in war crimes, we can think about it, but the focus on just genocide may in part be driven by the fact that we have a genocide convention and we don't have a crimes against humanity convention. In any event, those are some of the things. Another place you can look is some of the jurisprudence coming out of the European Court of Human Rights system and so on. In the commentary, the Commission lists out the following things. You need to adopt national laws and policies as necessary to establish awareness of the criminality of the act and to promote early detection of its risk, of any risk of its commission. You have to continually keep those laws and policies under review and, as necessary, improve them. The word effectively in our Article 4, Paragraph 1, effective legislative, administrative, and so on, that word effective is meant to signal a constant review of the measures you have in place, and if for any reason they are not measuring up, you're supposed to adjust them to make them better. We talk about pursuing initiatives that educate government officials as to this obligation not to commit crimes against humanity, and perhaps particularly importantly, training programs for police, military, militia, and other relevant personnel. So those are the types of things that fall within the scope of the third general obligation. Fourth obligation, states shall cooperate with other states, international organizations, and as appropriate, non-governmental organizations to prevent crimes against humanity. That duty of states to cooperate can perhaps first be noted in Article 1, Paragraph 3 of the UN Charter, because you may recall that the Charter says one of the purposes of the United Nations is to achieve international cooperation in solving international problems of a humanitarian character and in promoting and encouraging respect for human rights and for the fundamental freedoms of all. That's one of the main purposes of the United Nations. And then when you go to Articles 55 and 56 of the Charter, the prime articles dealing with human rights, it talks about all members of the UN pledging to take joint and separate action in cooperation with the organization for the achievement of these purposes. And that includes, of course, respect and observance of human rights. And then we have other instruments as well. The General Assembly in 1973 did a resolution focused on crimes against humanity as well as war crimes, where it talked about these types of cooperation. And so in the Commission's articles on crimes against humanity, Article 4, subparagraph B, we talk about this requirement of obligation to cooperate with states and international organizations. Now, you may have noticed that I said as appropriate with non-governmental organizations. This was a nod to the idea that they're in a little bit of a different category from states and IOs, that in some situations it will be very appropriate. The International Committee of the Red Cross comes to mind. In other situations, maybe less obvious that the cooperation is appropriate. Much will depend on the mandate of the organization, and much depends on the legal relationship between a state and both international organizations and non-governmental organizations. Okay, obligation number 5. Number 5, states shall not send a person to a place where the person would be in danger of being subjected to crimes against humanity. All right, so this is your basic non-refoulement obligation, and we might normally not think about that as a form of prevention, but the more the Commission looked at it, the more it occurred to us, yeah, this is a form of prevention. It's kind of a different way in which it's operating, but the idea is don't send people to another state where he or she might become a victim of crimes against humanity. So here in Article 5 of the Articles on Crimes Against Humanity, we wrote the following: no state shall expel, return, refouler, surrender, or extradite a person to another state where there are substantial grounds for believing that he or she would be in danger of being subjected to a crime against humanity. That type of non-refoulement provision, I mean, you can go back to the 1949 Geneva Conventions, particularly the Fourth Convention on Civilians, to find it. It's probably most famously embedded in the Refugee Convention in Article 33, although in that context it's only focused on refugees and it doesn't include extradition, at least not expressly in the obligation. As things move forward and this same type of obligation got embedded in other instruments, it did come to include any alien, any person, not just refugees, and concepts such as extradition crept into it as well. So we basically took the 1984 Convention Against Torture version of the non-refoulement obligation and embedded it in our instrument. Now, there's a lot of interesting jurisprudence surrounding the question of what does it mean to have substantial grounds for believing that a person would be in danger of being subjected to a particular crime, whether it's torture or, in this instance, crimes against humanity. And so we try in the commentary to evaluate the way that the Committee Against Torture has looked at that standard, the way that the European Court of Human Rights has looked at it, the Human Rights Committee, and so on. And there's a lot of good analysis there that talks about things like there being a risk, that the risk is that it's foreseeable of the act occurring, that it's personal to the individual. This particular individual may well be exposed. And good jurisprudence or analysis talking about the need for an independent evaluation of whether this is happening. That may be judicial, it may be some other body. So lots of good stuff that's over time played into that. You may be aware that the U.S., in the context of the Torture Convention, uses a more likely than not standard in this context. Many other countries don't use that standard, and so there are differences of views about this, but hopefully in due course an understanding will emerge that is, if not harmonized, at least in spirit, follows the same path. I'll mention one last thing about the non-refoulement issue, and that is how should we think about diplomatic assurances that a state receives that a person won't be harmed when you send them to that state. It's an important issue. We do talk about it in the commentary, and we point to things like the European Court of Human Rights, which has said the assurances must be specific. They can't be general and vague. And separate from that assurance, you need to think about whether these assurances can be objectively verified by other means, whether that's diplomatic or monitoring mechanisms of some sort, and so on. So we tried to address that particular issue, which has arisen in recent years. Okay, I should try to finish up. Obligation number 6, states shall punish atrocities as a means of prevention. Now, you could say this isn't really an obligation of prevention, this is an obligation of punishment, but again, I'll invoke the International Court's decision in the Bosnia v. Serbia case, where the court says one of the most effective ways of preventing criminal acts in general is to provide penalties for persons committing such acts and to impose those penalties effectively on those who commit the acts one is trying to prevent. So the idea is there is a link between these two, even if they are distinct obligations, prevention, punishment. In fact, if you set up a strong punishment system, you obligate states to adopt national laws, you obligate them to establish national jurisdiction, you have something like an autidere adjudicare obligation, right? Either submit the matter to prosecution or extradite. You know, that this is going to go a long way to potentially deterring conduct from occurring, and that serves a prevention objective. So we have in our Article 6 various measures that talk about this adoption of national laws and so on. Indeed, from that point forward in the Commission's articles on crimes against humanity, it's dominantly focused on punishment matters, but it is viewed by the Commission at least as part of a link back to the prevention concept. Let me just finish up. So those are the 6 obligations, overall obligations. As I say, there's kind of sub-obligations within them, and you have to look at both the draft articles and at the commentary to get the full contours. But let me finish up by just taking it in a slightly different direction, and that is to try to tackle the question of, does any of this make a difference, right? Does any of this make a difference? We've had the Genocide Convention since 1948. We have still had genocides since 1948, right? It may be great if we get a 2019 or 2020 Convention on Prevention and Punishment of Crimes Against Humanity. Is it going to make a difference, right? I think it's a fair question to ask. My answer would be, in part, that there have been studies in recent years about the effects of multilateral treaties on state behavior. Beth Simmons at the University of Pennsylvania has done some very interesting empirical work on the extent to which multilateral treaties of this kind or the Rome Statute, to what extent it has an effect. The results are somewhat mixed, right? Obviously, it's not ending all such acts that are subject to the treaty, but these studies do seem to conclude that they do have effects. Depends a little bit on the countries, the context, and so on, but that they do have effects. Why is it they have effects? Well, this is me speaking a bit more than what may be coming out of those studies. I think that by stigmatizing the conduct directly and expressly, and having states ratify a treaty that requires it often to go through their legislative processes, has a somewhat powerful effect in socializing states into what is permissible and impermissible behavior. I think it also has an effect in socializing people within a country about acceptable and unacceptable behavior. I do think, as I said before, that genocide has sort of captured people's attention in part because of the fact that there's a global treaty widely adhered to that directly takes on this is not okay. And therefore, I think there's reasons to say that other multilateral treaties, including one on crimes against humanity, might have a comparable effect. Second thing I would say is that what these treaties are really doing is very different from what happens for, say, the Rome Statute with the ICC. The idea in these treaties is not to create an international organization, international court, whatever. These treaties are attempting to reach down into the national legal systems and muck around with national laws and national policies, right? When that happens, you're harnessing the strength of the national legal system. To the extent that international law, as well developed and relatively robust as it is, still has some real weaknesses, some Achilles heels of one kind or another, that's less true of national legal systems. And so when you have treaties like this that are altering national laws and policies, you're maximizing the likelihood that you may well have some effect. Admittedly, the rogue states, A, they may not join such a treaty, B, if they did, they might flout it. That is going to be often the case. But there's plenty of other states out there, and those are the ones that may well be affected the most by it. And then the last thing I'll say is this idea of harnessing interstate cooperation and scrutiny is also quite important. You know, there was a time when it was accepted you could do whatever you want in your own territory, right? That's probably pre-World War II period, but you know, we're not in that world anymore. We're in a world where this type of scrutiny can and does happen. And I think to the extent that you have treaty obligations that are expressly calling upon states to take actions of one kind or another in cooperation with other states, cooperation with international organizations, that's an important way in which you, again, sort of reinforce the mechanisms that are possible in the international realm. I will concede that ultimately we may never succeed in preventing all atrocities any more than we've succeeded through laws on murder to prevent all homicides, right? I don't think that's what we're aiming for. I do think that if you view law as a means for channeling power into some kind of rule-based system, then the more techniques we exploit for doing so, then the better off the world's going to be. I'll leave it at that. I think we have 10 minutes or so if folks have questions.
Thanks very much for a really interesting and lucid presentation.
Sure, a mic's coming your way there.
Thank you. I have a question specifically about obligation 4, about the duty to cooperate. You mentioned duty to cooperate with states, intergovernmental organizations, non-governmental organizations. In the ILC's deliberations, did you also talk about a duty to cooperate with, let's say, large multinational private enterprises who have a significant capacity to exert influence over this sort of stuff? I don't think you specifically mentioned them in talking about who the duty to cooperate extends to, but I'm just curious if you talked about that or what the commentary may say about that.
We did not include anything about cooperation with private actors. It's a nice point, though. I think it's well worth raising. We did, in the context of the punishment side of the House, include in our Article 6 a paragraph that says states shall adopt as appropriate criminal, administrative, or other measures with respect to legal persons. So to the extent that one's thinking about corporate activity that's pernicious in nature, that is a part of the punishment side of the equation, but specifically on the cooperation side, no, I guess the answer is it only indirectly gets you there. Presumably if you can hang this possibility of you may be prosecuted or you may be fined or you may be dissolved if you keep doing this, that's present. But if it's some other form of cooperation, I guess it's not really there. Yeah. Other comments or questions? Todd?
Great presentation. Thank you very much. On the meaning of the obligation to prevent and the ICJ's articulation, have you, which is now incorporated into the Crimes Against Humanity proposed articles, have you gotten feedback from states yet on how they view that and their willingness to sort of include that in here, including have you gotten feedback from the United States yet?
Mm-hmm. Yeah. So the articles on prevention and punishment of crimes against humanity were completed in first draft in August of 2017. We then sent that first draft to all states and invited both governments and international organizations and others to submit written comments to the Commission by December 15 or December 1st of 2018. We also welcomed oral comments by governments in the Sixth Committee of the General Assembly in the fall of 2017 or 2018. All told, by the time you get to the end of 2018 or the very beginning of this year, we had received oral comments from approximately 70 governments, written comments from approximately 45 governments, written comments from about 8 or 9 international organizations, including the Office of the High Commissioner for Human Rights, the Interpol, the UN Commission on Crime Prevention, and so on. We received a lot of comments from special procedures mandate holders, so rapporteurs appointed by the Human Rights Council and other bodies sent in comments to us. And we received comments by or on behalf of more than 700 non-governmental organizations. The Commission has never received that level of comments ever in its history on any of its projects, which we took to be a good sign. It could mean you're not doing a good job, you need to do better. But we took it as a good sign in the sense that it seemed like there was a lot of interest in the project, a lot of enthusiasm for the project, comments both favorable and you should change this, but still generally good. On the prevention issue, were you asking on prevention generally or on a particular part of prevention?
Prevention as the court in
Bosnia v. Serbia. Yeah. So I would say that we definitely received comments from a number of governments, including the United States, you mentioned, that did talk about the prevention obligations. If I was to try to summarize what they addressed, it wasn't so much talking about Bosnia v. Serbia or what's behind Bosnia v. Serbia, except to the extent that there was uncertainty about exactly what's being required. In the original draft, we had been a little bit more open-ended in saying you shall take preventive measures, including, and then we would list a few things. And some governments, I think Australia raised this in their written comments, was like, well, okay, including, but what are all the other things that you're not putting in that list, right? What else is out there? So in the second draft, what we have tried to do is be more definitive in indicating the types of obligations that are at issue. I would say that if I was to finger which one of these is the one that there's maybe the greatest uncertainty about, it's that obligation number 2, that you shall use your influence to prevent others, right? Because it's one thing, I mean, obligation 1, don't do it yourself. Most states are going to say, well, we don't plan to do this. That's not what we do. You know, we may use force in certain circumstances, but we're careful about it. We try to discriminate. We're not attacking a civilian population. That's just not what we do. But the issue of don't, assist others or don't, use your influence to prevent others, that's a little bit more inchoate, and a lot depends on what does that mean. And I think some people looking at the ICJ's judgment in that context were a little bit unsure about the exact contours. So that is the part that might give states some pause. Nevertheless, we thought it was a valid form of the obligation to prevent. States always, in the course of negotiating a treaty, can make statements about their understanding of what it means. When they ratify the treaty, they might file an understanding as to what it means. I think there are ways of satisfying or resolving any concerns, but I think other than that, basically, there was an agreement to it. I will say one final thing on this point. The Commission's quite clear in the commentary and in the text of the draft articles that all of these obligations are subject to the rules of international law, which includes rules on the use of force. Now, we don't try to lay out what are those rules, right? We don't make claims about is humanitarian intervention permissible or impermissible. We don't try to, spell out what's the content of a responsibility to protect doctrine. Does the Security Council have to authorize, or in some circumstances not? We don't touch any of that. We just say whatever those rules are, they apply here. So if you take the approach that you can't, for example, engage in humanitarian intervention without Security Council authorization, then none of these prevention obligations allow you to go off and use force in the form of humanitarian intervention without Security Council authorization. We just don't really even address it. But whatever those rules are, they continue to apply here. Almost out of time, but maybe one more.
So, Sean, when I teach international law, we have a human rights unit where we do an exercise where we talk about what would be a utopian version of the human rights structure, and then we look at what we actually have in the international community. Let me ask you to have that thought process here. What was your utopian version of this convention, and what did we end up with? And what are the differences?
Okay. Well, it's a great question, and I think I'll answer it by maybe teasing out a little bit of the process that we struggled with at the Commission. Because at the outset, I think many members may well have had a bit of a utopian version of what might come out of this, a wish list of all the things you'd like to see in a global treaty of one kind or another that could involve all sorts of things. Let's say, for example, a committee that's going to monitor the whole thing as you have in some other committees. We don't have that. Stripping away immunities of all state officials, diplomats, consular officials, whatever. Banning amnesties. There's all kinds of things that one could imagine putting into a treaty that, depending on your views, it should be there or not. And I ended up mutating into a posture of wanting this instrument to be effective, but also wanting it to succeed, right? And at the end of the day, having the Christmas tree, if you will, of fabulous ornaments, but that no state wants to adopt as a treaty and no state wants to ratify it, it might feel good, but that's not what I was aiming for, and I don't think that's what the Commission was aiming for. So we tried to develop a relatively lean instrument that would be effective in doing a lot of really important things, some of which I talked about today, and yet was playing off of prior treaties that have been not just effective, but have been widely adhered to by states. And so it was this, trying to hit a certain point in the middle of the spectrum. That's not really telling you what my view of utopia would be, but it is telling you my view of why I think we got a good balance here, and that I hope ultimately it succeeds. Thank you. Thanks, Michael.
So what a great way to kick things off. And for those of you who are in international law and you're learning about treaties, now you know how the sausage is made. And we're going to be talking during the rest of the day about how international organizations make the sausage. Our next panel will be looking at legal challenges to the Security Council veto in the context of atrocity crimes. And then later we'll be talking about customary international law as it applies to atrocity crimes. We do have 15 minutes for a break, so please come back and we'll start immediately at 15 minutes before the hour. Thank you.